these lines right. Hey y'all, it's Zephyr Scalzetti. Welcome to They Better Get These Lines Right, where we're delivering the 411 on all things redistricting. Redistricting is our once-in-a-decade process of accounting for state-level population changes across the country to draw new district maps from the federal level to the local level, which makes an impact on how funding is distributed for healthcare, schools, and roads. Basically, everything that's important to you. This show is made possible by Alabama Values, a grassroots communication organization that uses the media and visual stories to raise awareness around what's happening on Alabama's political scene. On today's episode, we're diving into several ongoing Supreme Court cases that could radically shift the landscape of voting rights. All of these cases originate in the South, but the results of these decisions will impact the entire nation. Like we say, y'all, as goes the South, so goes the nation. We're going to kick it off by marking the anniversary of a really important Supreme Court decision, Shelby v. Holder. I know we've talked about this before, but the top line is that 10 years ago, the Supreme Court ruled in favor of Shelby County, Alabama in a landmark case. Shelby County felt like parts of the Voting Rights Act of 1965 were outdated and unfairly targeted them. Before this decision, Shelby County and the rest of Alabama had to get federal approval, also called pre-clearance, before passing new maps, closing polling locations, or changing their voting laws. The Supreme Court agreed with Shelby County and said that the formula used to determine which states and localities were subject to federal oversight, aka pre-clearance, was no longer valid. The decision in Shelby v. Holder was a blow to voting rights, especially for communities of color. It opened the door for voter suppression tactics to go unchecked, especially in the South. All of the other court cases we're about to talk about likely never would have happened if the Voting Rights Act wasn't weakened by Shelby back in 2013. Let's start in Alabama with Allen v. Milligan, previously known as Merrill v. Milligan. In Allen v. Milligan, black voters argued that under Section 2 of the Voting Rights Act, Alabama's congressional map should have 2 majority-minority districts. Currently, Alabama only has 1 black majority district, even though 27% of Alabama is black. The math is not mathing, y'all. If the Supreme Court hadn't sided with Shelby County in 2013, we wouldn't have to sue right now to get proper representation. Initially, back on January 24th, 2022, 3 federal judges, 2 of whom were appointed by Trump, ruled that Alabama should have an additional black majority district. Instead of redrawing the maps, the state of Alabama appealed to the United States Supreme Court, and SCOTUS heard oral arguments from both sides on October 4th, 2022. In the meantime, Alabamians were forced to vote for their congressional representatives under district lines that were unfairly drawn. A decision is expected to be handed down at any time, and just like Shelby v. Holder 10 years ago, this decision could have disastrous results for the Voting Rights Act of 1965. While we wait for this important ruling in Allen v. Milligan that will impact voter protections for everyone, Louisiana is facing the same fight under a different name, Ardoin v. Robinson. And it exists because, just like Alabama, Louisiana is dead set on not drawing a second congressional district that is majority black. So dead set, in fact, that when the governor of Louisiana vetoed the maps, the Louisiana legislature came right back and overrode his veto. Since the Supreme Court is hearing Alabama's case first, and it's all but identical to Louisiana's case, the ruling in the Allen v. Milligan case will likely set a precedent and influence the outcome of Ardoin v. Robinson. The long and short of it is, black and brown voters need the full and bolstered protections of the Voting Rights Act of 1965. Voting for black people in America has never been fair, and the courts have been their only protection. Which brings us up to North Carolina. Their Supreme Court case is Moore v. Harper. While the 2 cases we've talked about so far have pretty direct outcomes for voter rights, Moore v. Harper could give state legislatures near unchecked power over federal elections. Well, that's a lot to unpack. Let's back up a bit. Alabama and Louisiana's cases are based in racial gerrymandering, aka the practice of disenfranchising a group of people based on their race. In fact, part of the Louisiana fight is over who counts as black enough. But in North Carolina, the issue with their maps centers around partisan gerrymandering. Partisan gerrymandering is when you draw a map to make sure one political party wins more seats than the other. Now, racial gerrymandering is still illegal under the Voting Rights Act of 1965, but partisan gerrymandering has never been illegal federally. Some states have protections against partisan gerrymandering, and that includes North Carolina. So when the North Carolina legislature passed maps that were partisan gerrymanders, the North Carolina state courts blocked them twice. So the North Carolina legislature decided to take the fight out of state and advance a fringe legal theory all the way up to the Supreme Court of the United States. It's called the Independent State Legislature Theory, or ISLT, and it says that within states, the state legislature should maintain near total control over federal elections and are not subject to checks and balances. So let's break this down. If this theory were to be adopted, state legislatures would have more power in drawing congressional maps as well as administering federal elections, and could perhaps do so without being subject to state courts, governors, independent redistricting commissions, or even the state's constitution. Moore v. Harper could hand state legislators the powers to manipulate our elections and undermine our votes with no checks and balances from state courts or the governor. Just like Shelby v. Holder fundamentally weakened the Voting Rights Act, Moore v. Harper could fundamentally weaken democracy as a whole and significantly undermine all future elections. SCOTUS is expected to provide a ruling on Alabama's case Allen v. Milligan and North Carolina's case Moore v. Harper anytime. Whatever the outcome may be, advocates will continue to fight for voting rights, which is one of the cornerstones of our democracy. Tune in next time to They Better Get These Lines Right to stay connected and informed. The way the maps are drawn has an impact on so many issues that we care about, like voting rights, healthcare, criminal justice, reproductive justice, and education equality. Until next time, they better get these lines right.